Welcome, welcome, welcome. Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast, and a big hello to everyone in between. My name is Dan Balkaran, and I am going to be your employment lawyer for the next 30 minutes or so, answering all your questions about all things employment law. As always, please send your questions in. Quite often, a few questions at the beginning, and then they really come in fast at the end, and I don't get a chance to get to everyone, and I'd certainly like to get to everyone's questions today. Just a couple of items of housekeeping. As always, as you can see on the screen, if you need to get a hold of us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Okay, not very many questions coming in today, so send them in if you can. We've got one right now. Send more if you have them so I can get through them. Okay. Mervin asks, employed for 6 years with my company. I was bullied by a new manager. HR didn't even try to investigate. I'm now on long-term disability leave through Canada. I'm now on long-term disability leave. Got medical certificates from family doctor and psychiatrist stating not to work with my current manager, but the company will not accommodate. If I quit, I have no severance pay. I'm afraid of retaliation. Family members work at the same company are stuck. Okay, so first, you should speak to an employment lawyer right away. You've got a couple of different overlapping items going on there. You've got your disability claim. I don't know how long your long-term disability. Did you say it was long-term disability? Hold on. Yeah, long-term disability. I don't know how long it runs for. At some point, your insurer is going to try to get you back into work. They're going to say you're not disabled from working. Arguably under, I certainly am not a disability lawyer, but if you're able to work, just not with your manager, your insurer is going to say at some point you're not totally disabled from working, and it's not our fault that your employer can't accommodate your request. If human resource. So I don't know how long ago this happened, but certainly I don't know what provincial jurisdiction you're in either, but all jurisdictions will have some sort of government body that handles occupational health and safety. And so in British Columbia, we have WorkSafe BC. And so if you made a complaint and with respect to your safety and nothing happened, you could bring a prohibited action complaint in BC. I don't know what it's called in other provinces, or if there was retaliation against you for bringing that complaint, you would have what's called a prohibited action, which certainly can be fairly lucrative from a severance perspective or back pay perspective in certain circumstances. So you do have those avenues available to you, and you'd want to discuss those with an employment lawyer. If you're on disability, though, chances are that you can't double dip. So almost all disability, almost all insurers that provide you with disability are going to have in their disability or in their insurance contracts something that says that if you get income or severance while you're getting disability, to the extent of the disability that you get, it's clawed back out of the severance or the income. So you can't double dip, and you'd end up just at zeroed amount anyway. So a lot of this depends on how long you're going to be on disability for, what your insurance company is saying, what your doctor and psychiatrist say, what your end goal is going. Like, do you want to go back to this employer? Do you just want to leave and get money on the way out? I don't. Your employer is not under any sort of obligation to change your manager. You can't just strong arm the company and say, you have to, I demand a different manager because I don't like, what's going on with this particular manager. But if you have a legitimate complaint of harassment, bullying, that is, and harassment, bullying's got different people perceive different actions differently. So with harassment and bullying, it's a subjective, objective test. Do you feel that you were bullied and harassed? Okay, but what does a reasonable person think in your shoes? And so, they do have an obligation to investigate. And if they haven't, you could have claimed constructive dismissal. A little bit iffy if you could now because so much time has passed, but you went on medical leave right away because of it. And I'm trying to fill in a lot of the gaps because obviously you've sent in one paragraph and I haven't had a chance to talk to you about it. But certainly if they didn't investigate and some evidence confirming beyond just your own testimony about it, but some evidence confirming the actions of your employer, or specifically, sorry, your manager. And even without too much on that, the fact that you made a complaint, which is pretty serious, and they took no action, you could probably claim constructive dismissal. But, and I said this last week was the constructive dismissal week when I was on here talking to everybody. Constructive dismissal is where the actions of your employer effectively terminate you, but you're the one who has to initiate it. You're the one who has to say, well, I consider I construe your actions, employer, as a termination of my employment. And when you do that, you are effectively firing yourself. But you should never, ever, ever do that on your own. You should always do it with the assistance and advice of a lawyer, because constructive dismissals are too hard, they're too complicated, and the risks are too big if you get it wrong. So you certainly might have a constructive dismissal complaint or constructive dismissal claim, or you could claim constructive dismissal terminating your employment because they did not investigate your legitimate claims of bullying and harassment, depending on how much time went by. So in all circumstances here, it's very complicated what you're saying. And sorry, just to backtrack, the reason why you'd want to claim constructive dismissal is if you didn't have an employment contract, or your employment contract didn't contract out of the presumption of common law notice, which meant, to simplify, you'd be entitled to a lot of money in severance. That's why you'd want to claim constructive dismissal. So, and it's a way to get money on the way out the door rather than you just quitting. So, but that might not be what you want. Maybe you want an amicable solution where you can go continue to work at your employer. Maybe you like it there. Lots of different things. As you can see on the screen, you need to talk to an employment lawyer right away. If you want to talk to us, you can do so. employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. But Mervyn, it's really complicated, and you need legal advice before you do anything further. Okay. This is a question from Sir again. My employer wrongfully dismissed me. They told coworkers and customers I quit. I left. Is this right? Can I claim anything? Damages? Okay, so there's a whole bunch there to unpack. So first of all, wrongful dismissal is simply a legal term that means that your employer fired you and did not pay you the correct amount of severance. That's all it means. Okay, and so whether or not they did is a contractual question, and it's also potentially a question of an assessment of your age, length of service, position, and how long you're unemployed for. So it's not clear that from what you're saying that you have been wrongfully dismissed, but certainly you have been dismissed. So I think what you mean there, and a lot of people, when they say it, they mean that they were fired when they shouldn't have been. And that makes sense given the word wrongful, but that's not what it means. Your employer, to clarify, can terminate your employment, can fire you at any time without cause, provided it doesn't infringe on some other statutory protected right, like they can't fire you because of your ethnicity, for example. But otherwise, they can just say, well, we don't want to work with you anymore, so we're letting you go, and we're going to provide you the amount of severance that you're entitled to. So then they've fired you, but it's not wrongful, provided they provided you the right amount of severance. And so, we know they've terminated you. Were they legally entitled to? Well, as long as they didn't infringe some protected ground like age, race, ethnicity, sexual orientation, disability, one of the human rights protected grounds, yes, they could terminate your employment. They just had to provide you the right amount of money for doing so. And so that's a question that you need to get assessed. You should talk to, you say, can you claim anything? Yeah, maybe. It depends on what your employment contract says. And if you can get past your employment contract, or if you didn't have an employment contract, your age, length of service, position, and how long you're unemployed for or will be unemployed for. So that goes to the monetary amount. And then the second part of your question, and sorry, you should talk to, I sound like a broken record, but you should talk to an employment lawyer to assess whether or not you have not only a claim for damages, but whether they're substantial enough to warrant you moving forward. So again, if you need to get a hold of us, you can do so. Employmentlawyer.ca, help at employmentlawyer.ca, and 1-855-821-5900. Second part of your question, I told coworkers, the employer told your coworkers and customers that you quit. Okay, so that's not an independent cause of action. I mean, you said, is that right? Can I claim anything? It's not an independent cause of action, so you don't have a legal claim for that. But if they clearly did do that, and you have a wrongful dismissal claim, you can potentially piggyback their action, their conduct on top of it to try to strengthen your case and perhaps add some non-compensatory damages in there. I'd have to take a look at that a little bit more, but it could assist a wrongful dismissal claim you have, but it's not a claim of it in and of itself, if that makes sense. Okay, Mary Lou asks, my litigation process began because of termination of my benefits. Can I go back to work while in litigation? If doctor allows me, what am I going to lose in this? Mary Lou, I really don't know what you're asking. I don't know if you're engaged in litigation. Maybe you have a human rights complaint, but it sounds like your benefits were terminated. I think, are you on layoff? Can you clarify? I don't quite understand. Actually, I don't understand at all what it is that you're asking. My litigation process began because of termination of my benefits. Can I go back to work while on litigation? Well, litigation just simply means you filed a lawsuit against your employer or some other legal avenue of redress, like a human rights complaint or an employment standards complaint. So I don't think you've engaged in that. So just if you could let me know exactly what occurred, and I'll answer your question. I worked as a full-time truck driver, this is from Darren, for 3 years, was off on short-term disability, came back to work and had my job deleted. I don't know if were you fired? Yes, you were fired. They gave me 2 weeks notice, no severance. Oh, so they had you work 2 weeks of working notice. I was wondering if I'm entitled to severance. Okay, so I've been talking about severance the entire time through this broadcast today, but I think it's important to discuss first principles here. If your employer terminates your employment, your only legal right is actually to notice. Okay, it's not severance. It's to notice. It's a heads up saying, hey, Darren, the bad news is we're going to terminate you in 6 weeks. We're going to continue to pay you your paycheck for those 6 weeks, and hopefully we'll give you time off to look for another job, and hopefully you're not unemployed for very long, if at all. That's all you're entitled to. It's the heads up. It's the notice. It's the idea that the employer bears some societal responsibility for the financial ravages of unemployment, so the employer has to give you some more time to look for a job, so you're not without a job for very long. And then different factors, depending on what your contract says and your age, your length of service and position, sometimes you'll need a lot longer of a notice period to get a new job. That's all you're entitled to. It's just that it's called working notice. But if your employer chooses to terminate you today, okay, so your last day, they advise you the day that they terminate you today, and they've given you no notice, you're still entitled to that period of notice. It's just they can't give it to you because they terminated you today. And so that notice converts into money, the money you would have received had you worked out your notice period. and that money is called severance. Okay, so employers can terminate you by providing you with only notice, and that's what your legal entitlement is. They can provide you with severance or a mixture of both. And so your question is, are you entitled to severance rather than just 2 weeks notice? Well, it depends. You were there for 3 years. Depends what your contract says, because if you were there for 3 years, and you didn't have an employment contract that didn't contain, or a contract that didn't limit you to a small amount of severance, then you might be entitled to 3-4 months of severance. And if they've provided you 2 weeks notice, they still need to provide you with 2.5 or 3.5 more months of severance. So there is a possibility, depending on what your contract says. So you'll have to talk to an employment lawyer about that. The second thing I want to mention, though, is it looks like your employer fired you because of your medical issue. You were on short-term disability. You came back and they said you're fired. So this happens a lot. It's illegal. What happened was, while you were away, they hired your replacement, and then you tried to come back and they said, no, we're staying with the replacement. I'm guessing, I'm reading between the lines here, but it's probably what happened. And so you have, it would seem to me, if what I gleaned from that paragraph you provided is correct, you have a right under human rights. You have a claim under human rights. You were dismissed because you had a temporary disability. And under the human rights legislation in every jurisdiction in this country, your employer cannot discriminate against you on the basis of disability, temporary or otherwise. So you certainly have a human rights complaint. And if you have a severance claim, you can combine the two of them for maximum effect. Or if you don't have a severance claim, you can pursue your discrimination complaint, at least in BC, through the Human Rights Tribunal separately, which can result in what's called injury to dignity damages, which are, for the indignity of losing your job because of your disability. You could also get back pay, which is the same as severance. So, Darren, you should talk to an employment lawyer to get a full assessment of exactly what your claim is and what the value is, because I can't tell from just the short paragraph, but you certainly have a human rights complaint, it looks like, and you may have a severance claim. If you want to get a hold of us, you can see on the screen, employmentlawyer.ca, help@employmentlawyer.ca, at 1-855-821-5900. Okay. I think this is Archie. Can an employer refuse to bring you back after going on short-term disability? Are they allowed to suggest you should go on long-term disability if you've been cleared by a doctor to return? So these are always interesting questions. So first of all, just to make the distinction here, you're on medical leave. You're on medical leave. I know that it gets conflated for everybody, but you're on medical leave for whatever your medical issue is. Okay. The disability, the short-term disability, is just how you get paid while you're on medical leave. It's not the actual status you're on, it's the medical leave. And so what you're saying is you've been medically cleared by a doctor to return to work, and your employer has said, no, go on long-term disability instead. Go stay on medical leave. And so the question is that a termination of your employment? Well, if your doctor has cleared you unconditionally, if your doctor has said, Archie is medically cleared to come back to work on X date, and they don't let you come back to work, come talk to an employment lawyer, and we'll construe it as a termination of your employment and go after severance if it makes sense financially for you to do that. Okay, it might not, but certainly that comes up in my practice quite frequently. Now you would have to assess certainly what your employment contract says, how long you've been there, if it makes sense for you to do that. Where it gets a little more confusing is if your employer said, yeah, Archie can come back to work on a gradual basis with the following restrictions. Okay, so let's just say you work in construction and your job requires you to lift 80 pounds and you can only lift 60. Okay, well, that becomes a much harder question, because is your employer required to, your employer is required to accommodate under the human rights regimes in every province your disability to the point of undue hardship. But what is that? And that goes to the center of what the actual job is. So if your job is, lifting 100 pounds all day long every day and you can't do it anymore, then arguably the employer doesn't have to accommodate that. And also it could be that you're medically unable to perform your role such that your employer's all of its obligations to you, including severance, are just extinguished. It's called medical frustration. So these types of claims can be very complicated and turn on what is required by your position, what is it sort of a core duty of your position, and then what is the nature of your injuries, your medical clearance, that kind of stuff. So Archie, you really need to talk to an employment lawyer right away to see if you want to treat this as a termination. You also have a human rights complaint, human rights entitlement, given the fact that they're not letting you come back to work when you're medically cleared to go back to work. Can your employer suggest, I think your question was, can your employer suggest that you go on long-term disability? Well, your employer needs to either let you come back to work or explain why they're not doing so. And then you can assess with a lawyer from there whether or not you have any action to take based on what their response is. Suggesting you go on long-term disability, I don't know what kind of solution that is. I don't know why they're doing that. I don't think the suggestion even in and of itself is an actionable a problem or issue, but it does make them look bad. Unless you want to go on long-term disability because it provides you with income for the next year while you recover from your injuries. So there's a lot going on here, and I don't know all the details and particulars. I do know you should talk to an employment lawyer right away. And I'll just say, whatever action that you take, make sure that everything is medically papered. Get your doctor's notes, get them in order, constantly update or continually update your employer. Make sure they have all the medicals in their hands. Again, if you want to get a hold of us, employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Joe asks, if part of your salary is commission, is it okay for an employer to change the percentage you receive without permission? Okay, so this is the ongoing battle between employers who pay commission and employees who receive commission, and employers trying to claw back the amount of money that they pay to employees in commission. If I've seen it countless times, if the employer is paying more than it wants to in commission, it'll redo the commission structure of the employee's employment to try to pay them less. And so the question is, what is your entitlement arising from that? Well, if commission forms a very small part of your compensation, then probably none. But if it's a big chunk of it and your overall compensation goes down by, I think the rule in BC, I don't know about other provinces, but the rule in BC, it'll be substantially similar, is 10% and some other things like a loss of a demotion, loss of prestige, some other reduction in your status can be a constructive dismissal. Below 10% in overall decline in your pay, not going to be there. Up to 20%, you probably need something else, although not always. Between 10 and 20 can certainly be a constructive dismissal on its own. Anything over 20 is probably, rule of thumb, generally going to be a constructive dismissal, even with nothing else on top of it. So depends on the details of how much your overall compensation has been reduced, and then what that would get you to is simply a constructive dismissal, which is where you pull the trigger on your employment, you terminate yourself effectively. And remember what I said earlier, no one should do that on their own. You need the advice and guidance of a lawyer to claim constructive dismissal. It is too dangerous for you to do otherwise. You can vaporize your entitlements if you do it on your own. You need to coordinate with a lawyer. So, and why would you want to do that? Because it's a way, maybe you've decided you're not going to work there because your employer keeps trying to reduce your pay and you want to get out with some money, and the nature of your employment contract and structure of your pay is such that you can get a reasonable amount of money on the way out the door by claiming constructive dismissal. So, all of these are complicated questions. You need to talk to an employment lawyer right away. Employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. So just to that last point about speed, there's no hard and fast rule, but generally speaking, if your employer makes a unilaterally imposed change to a fundamental term of your employment, like pay, how much it pays you, you've got about 2 months from the date of the change to object to it, i.e. pull the trigger and on your own, I'll phrase that differently, effectively terminate your own employment by claiming constructive dismissal. You've got about 2 months to do that, after which time you're deemed to have accepted the change. So you can't come back in 6 months and say, hey, 6 months ago you changed my pay, I'm claiming constructive dismissal. Courts will say, well, you accepted it. It was too long ago. Too bad. So you've got a short amount of time to act. Talk to a lawyer right away. Okay, Darren asks, I came back from short-term disability. I think this is the same Darren. 1 hour into my shift, they gave me a letter of 2 weeks working notice. Yes, Darren, I believe I answered your question already. Mary Lou is back. Termination of my benefits for long-term disability means constructive. No, probably not. Depends on so the value of your benefits has to be substantial to your overall compensation. I just talked about, and you said you'd already claimed constructive dismissal, so I'm not, or you were in litigation, so I don't know what you mean by that. But certainly there are cases where benefits termination has resulted in a constructive dismissal being found, but it has to be a fundamental term of your employment that is eliminated or substantially reduced. And benefits for most people, extended health, extended medical, these are minor items. They're not going to get over the threshold of fundamental term. It's got to be a fundamental term. I mean, the core of the test is, if a judge put him or herself in your shoes, could the judge continue to work there after that part of their compensation was taken away? And if the answer is no, because it's clearly a fundamental term, like, I don't know, your pay has been reduced by 50%, then it's a constructive dismissal. But benefits are very ancillary. They're marginal. So depends on what those benefits were. Are there industries that are exempt from paying severance? Oh, that's a complicated question. How many questions do we have left? Oh, just a couple. Okay. So everyone who is a provincially regulated employer gets employment standards, minimum notice, and or severance, depending on. Well, we're just going to go a few minutes long, so I can just answer these last two questions. But yes, join us next week with Luke Serdaw, April 29th, 1:30 p.m. I'll be back in 2 or 3 weeks because I'm not here next week. But short answer is common law severance, no. But employment standards severance, professions are exempt. So, and in some situations, construction workers, but lawyers, doctors, accountants, architects, dentists, those kind of professionals are exempt from employment standards minimum severance. This person, I'll call this person H. I work in a call center. I got terminated. I follow all procedures. I want to go legal with this. I would like to go to court. Is it possible? Well, it depends on what your employment contract says and what the value of your claim is. So I would encourage you to talk to an employment lawyer right away. And if you want, you can talk to us, help@employmentlawyer.ca, employmentlawyer.ca, 1-855-821-5900, and we can assess it and let you know. Last question. Louis asks, reduction in status and prestige and job title change, but not salary from senior leadership to individual contributor. Is it generally constructive dismissal? Okay, it's a great question. A reduction in your pay over 20%, hours over 20%, almost always going to be a constructive dismissal. If your salary does not change, but you're demoted, it can be a constructive dismissal, but the prestige loss has to be substantial. Title goes along with it. Certainly it can be, but I will tell you, these are very hard cases. They're the hardest ones to get a constructive dismissal. You've got to account for risk in whatever the resolution is. There's risk on both sides, but yes, it certainly can be, and I've certainly had those cases. I have a few every year, but certainly challenging. You want to get good legal advice on that front. If you want to talk to us, employmentlawyer.ca, help@employmentlawyer.ca, at 1-855-821-5900. And Louis, it's just because, if your pay hasn't changed, can the other changes be considered fundamental? Well, certainly they can be, because we get more, what's the word we're looking for? Satisfaction, personal satisfaction in life from our work than just money, right? And so if leadership, for example, was where you derived all your personal satisfaction from, and now you're not a leader, you went from senior leadership to individual contributor, that could be a substantial demotion, and certainly that could be a constructive dismissal. But they're very difficult, but certainly worth talking to a lawyer about. Okay, so please contact us if you can. We went a little bit long. Thank you for all the great questions. I think I'm not back for 3 weeks. I think that's correct, 2 or 3 weeks. So I'll see you then. Join us with Luke on Monday, 1:30. I can't remember if that's Eastern time or not. Thank you for the great questions. As always, have a wonderful and safe weekend, and I will see you next time.